Chapter 34 Partition Analysis Section 701 Partition, in general. In its original and technical meaning, partition signified the division by culparciners or co-heirs among themselves of lands which had descended by common law or by custom. Its later signification included the division of lands, tenements and hereditaments by joint tenants and tenants in common. The term has now come to mean the division or allotment made among several persons of real or personal property belonging to them as CO owners. Partition may be either voluntary, by agreement of the parties acting directly or through arbitrators, or compulsory, by means of judicial proceedings. While originally only courts of law recognized the right to partition, courts of equity very early assumed a concurrent jurisdiction. Under modern modified statutory procedure, the right is generally enforced by a special action in courts having both legal and equitable jurisdiction. Section 702 Common Law Remedy. When an inheritance descended to more than one heir, and they could come to no agreement among themselves concerning the division, a proceeding might be instituted by writ of partition, in which a division would be made and each heir be put in possession of a certain portion in severalty. At common law, the writ of partition lay only in case of lands held in coparcenary. Its use was confined solely to coparceners or to one coparcener against a third person claiming title from a coparcener. The remedy was afterwards extended by statute to joint tenancies and tenancies in common, and included not only estates of inheritance, but also estates for life or for years, and estates in which some of the CO tenants held for life or years and others held estates of inheritance. Where the tenure was copyhold, partition might be had in the Lord's court by a plaint in the nature of a writ of partition. This plaint and writ were abolished by statute, and there was no remedy, even in equity, for the partition of copyhold estates until jurisdiction was conferred upon the chancery courts by statute. The operation of the common law remedy, even after its extension to joint tenancies and tenancies in common, was imperfect and narrow. The writ of partition lay only against the tenant in possession, and was incompetent to reach the remainder man or the reversioner. As the judgment at law proceeded according to the titles proved, it was necessary for the plaintiff to show the title of the defendant as well as his own. And as partition at law was made by the sheriff by actual division, it might happen that, where the undivided interests were incapable of exact apportionment, the judgment of the court would be powerless to compensate the inequalities. Moreover, a court of law was unable to adjust the often complicated rights of the parties, as where one co-tenant had laid out large sums for improvements, or had erected valuable buildings, or had been in receipt of all the rents and profits. A court of law could not order a sale, but could only make an actual partition, although this might often work a great hardship or even result in a virtual destruction of the property. Section 703 Equitable Jurisdiction. The origin of the jurisdiction of the courts of chancery in cases of partition, while assumed to be very ancient, has never been satisfactorily accounted for. As early as the reign of Elizabeth, partition became a matter of equitable cognizance, and now the jurisdiction is established as of right in England and in the United States. The ground of the jurisdiction is sometimes stated as resting upon the principle of convenience, and sometimes as an ordinary case of discovery in aid of a legal right. The true ground, however, is found in the inability of courts of law to furnish a plain, complete and adequate remedy, and in the case of personal property and equitable interests, in the absence of any legal remedy at all. While the jurisdiction of equity is concurrent, as to legal interests, it has, owing to the advantage possessed over the common law court in being loose and free from all technical restraints, and to the powers it possesses of dealing with and providing for the various interests it may meet with, practically become almost exclusive. As to personal property and equitable estates, its jurisdiction is exclusive. In exercising its concurrent jurisdiction, equity follows the analogies of the law. All of the states in this country have provided a statutory remedy for partition. These statutes are in substance enactments of the common law and equitable remedies, and partake of the nature of both. Sometimes the jurisdiction is conferred upon courts of law, sometimes upon courts of equity. but more frequently upon courts exercising both legal and equitable jurisdiction. The statutory remedy is generally held to be cumulative and does not supersede the original jurisdiction in equity. Section 704. Property subject to partition. In general, following the analogies of the law, equity will grant partition only of property held in co-tenancy and in which the parties have a community of interest, either as co-tenants, tenants in common, or co-parceners, and this rule has not been materially affected by the statutory remedy of partition provided in all the states. Several persons may be owners of the same property without being co-tenants, and the severance of their interests may be desirable or even essential to the enjoyment of such property, but this constitutes no ground for equitable interference by way of partition. If the requisite of co-tenancy be present, all kinds of property are subject in equity to partition, whether it be corporeal or incorporeal, real or personal, and whether it be held by legal or equitable title. Section 705. Personal property. The rules and proceedings which obtained at common law and by statute on the subject of partition related exclusively to real estate. At common law, the co-owner of a chattel could maintain an action respecting the common property against his co-tenant only where a loss, destruction, or sale of the property was provable against the defendant. However expedient the partition of chattels might appear, or however desirable it might be to the co-tenants, the common law furnished no instrumentality by which the partition could be judicially effected. There was not merely an inadequacy of legal remedy, there was an utter absence of it. The situation clearly demanded the intervention of equity. And although the inception of the equitable jurisdiction for the partition of chattels is not traceable with certainty, the jurisdiction itself is unquestioned, and where a literal partition is not practicable, the court will order a sale. The jurisdiction of equity over the partition of chattels is exclusive, and extends even to the settling of disputed titles. Section 706. Future estates. The object of the action at law for partition, as it lay among co-parceners and later among tenants in common and joint tenants, was to obtain relief from the inconveniences and embarrassments incident to the joint occupation of land and to gain the advantages of a tenancy in severalty. The remedy had special reference to present possession. Estates in remainder and in reversion were, therefore, not subject to partition at law. Unless modified by statute, the rule is the same in equity, and a bill will not lie to partition a future estate unconnected with an estate in possession. While a future estate cannot be partitioned in equity at the suit of a co-owner thereof, the owners of future estates may be made parties defendant to a bill by the owner of a particular estate and may be compelled to execute conveyances for the purpose of carrying out a decree of partition by statute in some of the states. It is provided that partition may be had when two or more persons are interested in real property as joint tenants or tenants in common. This has been held to authorize a partition of an estate in remainder or in reversion. Section 707. Incorporeal and other property. Because of the facility with which courts of equity can deal with the numerous and complicated interests arising from the common ownership of various sorts of property, there is a peculiar fitness in resorting to those courts, where relief is obtainable in many cases in which the parties would be practically remediless at law. Thus, on a bill to partition the use of waters, equity will decree the use thereof for alternate periods by the parties, on will assign to each owner so much water as will run through a gate of certain dimensions or through certain channels of the river. Where property is not in its nature severable, the profits may be divided or alternate occupation decreed, or the property sold. Mining rights may be partitioned by sale and a division of the proceeds, if they are so created as to amount to legal estates of freehold, and are not mere licenses to dig on another's land. Co-owners of growing timber or of crops raised jointly may have partition. Real estate held by partners for partnership purposes is not subject to compulsory partition unless it is clear that the other property of the firm is ample to meet the firm obligations. In England, however, the real estate of a partnership is regarded as so essentially converted into personalty that it cannot be judicially partitioned. No partition in equity can be had among co-tenants of property held by entirety until the tenancy has been converted into a tenancy in common by proper judicial proceedings. Section 708. Limitations on the right to partition. Although there are a few cases to the contrary, The rule is practically universal that a CO tenant is entitled at law to an actual partition as a matter of absolute right, and the fact that the division will result in great hardship and inconvenience or the virtual destruction of the property is no reason for withholding it. A co-tenant need not assign any reason for desiring a partition, it is sufficient if he wishes to enjoy his estate in severalty. Equity followed the law in this regard and decreed an actual partition notwithstanding manifest hardship. While equity treats the right to partition as absolute, it is not restricted, as is a court of law, to an actual physical apportionment according to titles proved, but having control of the parties and greater freedom of action, it may mollify the hardships by adjusting the adverse interests and by making such an allotment as will most nearly effect justice and equality among the parties. As is shown elsewhere, a court of equity formerly laboured under the same disadvantage in England as a court of law in not being able to order a sale of the property without the consent of all the parties interested. In this country, however, statutes were early passed conferring this power upon equity courts so that in proper cases a sale and a division of the proceeds may be decreed. While the character of the property affords no bar to a partition, there are many cases in which equity will refuse to decree a division, as where property is charged with some trust or is dedicated to some use which would be defeated by the partition. There can be no partition which will defeat the purpose of a valid trust created by deed or will. Nor will equity grant a partition contrary to the expressed desires of a testator. Where, however, all the beneficiaries under a trust consent to a partition, equity may order the same and terminate the trust, or may order the property held for the beneficiaries in severalty, provided such termination or holding will not defeat the objects of the trust. Where property is devoted to a public use, no partition detrimental to public right or policy will be permitted. And where property is devoted to a religious or charitable use of such a nature that a partition would be especially disastrous, equity will not enforce a division. A homestead is regarded, in most of the states, as appropriated to a use which requires its occupancy as a whole, and a partition thereof cannot be had among the heirs of the deceased owner. The inchoate right of dower which may exist in favour of the wife of a co-tenant does not prevent a compulsory partition. On a division of the land the dower right attaches to the moiety set apart to her husband. Where, however, the right of dower exists before the CO tenancy arises, partition can only be had subject to such right. Certain interests cannot be partitioned because of the effect on the rights of third persons. Nor will equity entertain a bill for the partition of land which has already been partitioned by agreement of the owners. There is some authority for the view that an agreement among co-tenants not to partition their common property is invalid, either because it is repugnant to the partible quality which is an essential characteristic of such estates, or because it is a restraint on alienation and contrary to public policy. It would seem that an agreement never to partition might be subject to the latter objection. The prevailing rule, however, is that the right to a compulsory partition is given for the benefit of co-tenants and may be waived by agreement, and where such a stipulation is an incident to the purchase of lands or other property for the carrying out of a common project to the success of which the preservation of the property as a whole is essential, equity will not compel a partition in violation of the contract. Section 709, who is entitled to partition, unless modified by statute or subject to exceptions hereafter noted. The general rule in equity, as well as at law, is that a party applying for partition must not only have a present estate in the property, real or personal, as joint tenant or tenant in common, but he must also have an actual or constructive possession of his undivided share or interest therein. But he will be aided by the presumption that possession usually follows the legal title when no adverse possession is shown. In equity, as at law, a pending lease for years to a third party or to a CO tenant is no obstacle to a partition between the owners of the fee. The grantee or assignee of the share of a co-tenant acquires all the rights of his grantor to enforce partition. A mortgagor may at any time before foreclosure maintain proceedings for partition, subject to the interests of the mortgagee. A mortgagee, being generally regarded in this country as having only a defeasible title before foreclosure and the expiration of the period of redemption, is not entitled to have partition, but after his interest becomes indefeasible by reason of appropriate proceedings had to cut off the equity of redemption, he may have his interest set aside in severalty. Reversioners and remainder men, while liable to be made defendants in a suit in equity to enforce partition, cannot bring a proceeding for that purpose. In a few states, however, estates in remainder or reversion may be partitioned at the suit of the co-owners. A co-tenant for life or for years may, either at law or in equity, enforce partition of the particular estate, and in equity may make the owners of the future estates parties and have such a decree as will fairly adjust all the interests in the estate. While an infant may enforce partition, equity does not, as with an adult, regard the right as absolute, but subject to such limitations as the court may deem essential for the protection of the interests of the petitioner. A partition in equity proceeding upon the theory of mutual conveyances, the court, in cases where the interests of infant co-tenants are involved, is obliged, by reason of the incapacity of the infants to execute valid conveyances, to make an allotment and to quiet the possession of the respective parties until the disabilities of infancy were removed, when conveyances would be ordered. In some jurisdictions, heirs to whom real estate has descended may, although the same is in the possession of an administrator and still liable to be taken for the debts of the ancestor, enforce a partition. A tenant in dower not being a co-tenant is not entitled to enforce partition, but a tenant by the courtesy of land held in co-tenancy may have a division. Section 710. Effective decision. The object of the proceeding in a petition for partition being to turn an estate that is possessed in common into an estate in severalty, and not to furnish a method for settling conflicting titles. A co-tenant who has been decised and has only a mere right of entry cannot maintain the action. Only those persons who are co-tenants may have partitions. If, therefore, one is effectively decised, whether by his co-tenant or by a stranger, he is no longer holding an estate in co-tenancy. He must first establish by an appropriate action his status as a co-tenant. There must be an actual and total ouster. Mere possession by one co-tenant to the exclusion of the other does not necessarily work a decision. Possession usually follows the legal title when no adverse possession is shown, and consequently, when one of several co-tenants is in possession. His possession will, in the absence of an active ouster on his part, inure to the benefit of all. In some states, it is sufficient if a co-tenant shows a requisite title, notwithstanding he is out of possession and the property is held adversely. The tendency is to adjust all the conflicting rights in one action, and this is often made possible by statutes conferring general and enlarged powers over legal and equitable remedies upon the same court. Section 711. Decision, rule in equity. The rule that a plaintiff co-tenant cannot have partition of property held adversely to him is followed in equity, but with certain qualifications. Where the questions are such as belong to a court of equity, there is no reason, after having assumed jurisdiction, to suspend the proceedings short of complete justice. Thus, a court of equity has exclusive jurisdiction to determine the validity of an equitable title. If, therefore, jurisdiction has been assumed for this purpose, the court may proceed to determine the whole controversy, including the awarding of a partition, notwithstanding the adverse claim of the defendant. Equity having acquired jurisdiction to set aside a deed, may go on and determine title and make partition. Where the jurisdiction of equity was invoked to secure construction of a will, the court, having secured jurisdiction on that ground, gave a decree for an accounting and a partition in the same proceeding. The jurisdiction of equity over the partition of personal property being exclusive, and there being no remedy at law by which a dispossessed co-owner of a chattel may regain possession, a refusal by a court of equity to pass upon an issue of title would be tantamount to a complete failure of justice. Courts of equity, therefore, when partition of personalty is sought, have of necessity departed from the analogies of the law of real estate, and have assumed jurisdiction to determine as well the issue of title as any other issue pertinent to the case. Section 712. Disputed title. The difficulty under which the complainant labored at law in proving the title, as well of the defendant as of himself is, in equity, obviated by a discovery, and if need be by a reference to a master. The complainant must show title in himself, and such a title as will establish his right, as against the defendant, to a partition. Where the complainant's legal title is disputed, courts of equity decline the jurisdiction to try this question, but, in analogy to the case of dower, they will retain the bill for a reasonable time, until the issue of title has been determined at law. In several states, courts of equity are authorized by statute to determine questions of title arising in partition suits. If the disputed titles are equitable, courts of equity will exercise jurisdiction to settle them, and will then grant final relief by way of partition, under the same bill. Where the subject matter of the suit is an equitable estate, or an incorporeal hereditament, a partition may be had in equity. Section 713. Parties defendant. It is of the first importance to a successful partition that the title to the per parties allotted be free from cloud, and to accomplish this result it is necessary that all persons interested as co-tenants in the estate to be partitioned be made parties. The general rule in equity, as to parties, is that all those must be made parties whose interests in the subject matter of the suit, and the relief sought, are so bound up with that of the other parties, that their legal presence as parties to the proceeding is an absolute necessity, without which the court cannot proceed. All co-tenants, therefore, of the estate sought to be partitioned must be made parties, as they are persons who not only have an interest in the controversy, but an interest of such a nature that a final decree cannot be made without affecting that interest or leaving the controversy in such a condition that its final determination may be wholly inconsistent with equity and good conscience. The rule is confined to the CO owners of the particular estate before the court, and does not, in the absence of statutory modifications, extend to persons having other estates in the same property, although they may be made parties. Thus, partition may be had of a particular estate, as for life or for years, although the owners of the remainder or reversion are not parties. There may be a partition of equitable estates without the presence of those in whom the legal title is vested, or of legal estates without bringing before the court the owners of the equitable interests. While the co-tenants of the estate sought to be partitioned are the only necessary parties, it is frequently desirable, in order to adjust in one proceeding all the rights involved, to make the owners of other estates parties, and it is the virtue of equity that it can thus effect a partition of various interests. As only those who are parties to the suit at the time the decree is made are bound thereby, it is essential, except where survivorship applies, in case of the death of a co-tenant, during the pendency of the proceeding, to bring in his heirs or successors. The grantee or assignee of a co-tenant's share, whether by metes and bounds or as an undivided moiety, is a necessary party. The purchaser of joint property, or of an interest therein, pending a partition need not be brought in as defendant, provided the suit is prosecuted with reasonable diligence. Section 714. Persons under disability. As the jurisdiction of the court in partition suits does not depend upon the character of the co-tenants, but upon the fact that property is held in co-tenancy, the right of co-owners to enjoy their estates in severalty is not destroyed because some of their number are under a legal disability. While equity is especially solicitous for the interests of infants, it does not regard the infancy of one of the parties as sufficient reason, in itself, for denying partition. Infant co-owners must, therefore, be made parties, and if they are brought before the court by appropriate process and duly represented, which matters now are extensively regulated by statute, the decree of partition is binding upon them. A court of equity will, however, always relieve an infant from the effect of a partition if it appears that his interests have suffered by reason of fraud and collusion. The rule requiring all co-tenants to be made parties extends to femmes covert, and their interests may be effectually bound by the decree, unless it is clear that they acted through mistake or in ignorance of their rights. Lunatics and others suffering from mental incapacity, so long as they are vested with a title to a moiety of the estate sought to be partitioned, are necessary parties. Section 715. Holders of particular estates and interests. The holder of an encumbrance or lien, created by mortgage, judgment, or otherwise, upon the undivided interest of a co-tenant, is not, in the absence of statutory requirement, a necessary party to a bill for partition. Upon partition, the encumbrance is transferred from the estate in common to the estate in severalty of the tenant against whose moiety the lien was a charge. Even where partition is by sale, encumbrances are not necessary parties, unless made so by statute. As the power of courts of equity to order sale in partition proceedings is wholly statutory, the statutes conferring such power usually contain provisions for bringing lien holders before the court, ascertaining the amount of the liens, and preserving the security by attaching the lien to the co-tenant's share in the proceeds. The wife of a tenant in common is not a necessary party to a suit for partition. If an actual partition is made, her right of dower will attach to the share allotted in severalty to her husband. This results as a matter of course, without any decree or order of the court, and without her being before the court as a party. Nor is the widow of a deceased tenant in severalty a necessary party in a partition proceeding among the heirs, since she is not a co-tenant with them, inasmuch as a husband cannot, without the wife's consent, cut off her inchoate right of dower. It is held that in all cases where a sale of the property will probably be necessary, the wife should be made a party, so that the purchaser's interest in the premises will not be charged with her contingent claim of dower. On the other hand, it is said that the wife's right of dower subsists in virtue of the seizin of her husband. The liability to be divested by sale in partition is an incident which the law affixes to the seizin of all joint estates, and the inchoate right of the wife is subject to the same incident. By statute in many states, the wife may be made a party, and a decree entered ordering a sale and an award to her of a part of the proceeds in lieu of dower. The husband of a co-tenant is a necessary party defendant in a partition proceeding, brought during her life or after her death, for the division of lands held by her as co-tenant. While an outstanding lease is no obstacle to a partition of the reversion among the co-owners, a lessee of a moiety or of the whole of the estate must be made a party defendant in order to effect his interest. Section 716. Estates of persons not in being. As has already been shown, the jurisdiction of equity in partition suits is not limited to the division of present estates in possession, but extends to the estates of remainder men and reversioners, and other owners of future and contingent interests. It is also within the established jurisdiction of equity to bind the estates of persons not in being who may become co-owners of property. This is accomplished by means of the principle of virtual representation, by which the tenant for life or of the inheritance, being brought before the court, is regarded as competent to represent both his own interests and the interests of all those who may by their subsequent birth acquire interests in the estate. In order to bind such interests, the bill should set out specifically the various estates involved, so that the court may in its decree protect the rights of persons not in being by substituting in place of the land the fund derived from its sale and preserving it to the extent necessary to satisfy such future interests as they arise. Section 717. Incidental relief in equity. In general, it is characteristic of equity in matters of partition that not only does it afford a more advantageous and adequate relief than is obtainable at law, but it also takes into consideration the various and diverse equities of the respective parties growing out of their ownership of property in common, and adjusts and disposes of them upon broad principles of fairness and equality. This incidental relief extends only to such equities as arise out of the relation of the parties to the joint property, but this may include the disposition of matters preliminary to final partition and to the management of the property pending the partition proceedings. Thus, a deed or devise may be construed, or a mortgage reformed and foreclosed and the manner of its payment be prescribed, or deeds may be corrected and conveyances ordered. If the maintenance of the property and the preservation of the rights and interests of the parties require it, the court may appoint to receive a pending partition. When a tenant in possession is making an unusual or improper use of the premises to their detriment and waste, the court may, if such tenant be pecuniarily irresponsible, grant an injunction, either in the suit for partition or in an independent proceeding, to stay waste. Equity will also enjoin the prosecution of a partition at law when such interference becomes necessary to protect some of the co-tenants from fraud or wrong, or to secure them some clear right which a court of law, from the manner of proceeding before it, cannot secure. If it can be done without prejudice, a partial partition may be ordered by setting off to the complainant his moiety and leaving the other co-tenants to continue their ownership in common. Section 718. Out of partition. In the original jurisdiction of equity the partition was effected by means of mutual conveyances, and where the land was incapable of exact or fair division, the court had power to compensate for the inequality by awarding what was known as out of partition, being a pecuniary compensation or charge upon the more valuable share, by way of rent, servitude, or easement, in favor of the less valuable one. This charge rests upon the land alone and not upon the person of the CO tenant, and may be enforced forthwith by the appropriate proceedings in rem. It constitutes an encumbrance in the nature of a lien upon the moiety against which it is assigned, and follows the land into the hands of third persons, and is prior to other encumbrances existing against such moiety. Unless made so by the decree, the payment of our is not a condition precedent to the vesting of the title to the portion upon which it rests. Our awarded to a CO tenant whose share is encumbered should be applied to the payment of the encumbrance. Section 719, Improvements. In making partition, equity will take into consideration the fact that one co-tenant has occupied a portion of the common property and has enhanced its value by making useful improvements thereon, and will, so far as it can do so consistently with an equitable allotment, assign to the tenant making such improvements the land on which they stand, or so much thereof as represents his proportion. In some cases, however, either by reason of the nature of the property or the location of the improvements, it will be impossible to apportion the land in such a way as to give a CO tenant the benefit of his improvements. In such a contingency the general rule seems to be, that a co-tenant, acting in good faith and for the purpose of honestly bettering the property, and not for the purpose of embarrassing his co-tenants, or encumbering the estate, or hindering partition, will be entitled to compensation to the extent that his substantial and useful improvements have added to the value of the common property. It does not appear to be necessary to show the assent of his co-tenants to such improvements, or a promise on their part to pay their portion of the cost, nor a previous request by him and a refusal by them to join in the work. Against the award for improvements may be set off such sums for use and occupation as may, on an accounting, be found chargeable to the tenant making the improvements. Section 720. Accounting. There is hardly any question arising out of the relation of the parties to the common property which a court of equity may not determine incidentally in a suit for partition, for the purpose of doing complete justice and preventing multiplicity of litigation. A bill for partition may include a prayer for an accounting against the defendants, and the defendants may by cross bill have an accounting against the complainant. Thus, if one of the joint owners or owners in common has received more than his share of the rents and profits, or has occupied the common property to the exclusion of the other co-tenants, the court will direct an accounting for the purpose of decreeing a reimbursement or the payment of rent for use and occupation. Where there are encumbrances resting upon the property, the court will ascertain their extent and validity and apportion them according to the rights of the parties, or in case a co-tenant has paid a common encumbrance he may, in a suit for partition, enforce contribution from his co-tenants. If one tenant has committed waste upon the common property, the court may assign to him the wasted portion or decree compensation to be made for such waste. Reimbursement may be had for expenses incurred in recovering or preserving the joint property. Section 721. Mode of partition. The method of making partition is now generally prescribed by statute. While varying in the different states, it is in substance the procedure originally followed in equity. The court first decides whether the parties are co-tenants and are entitled to partition. If so, the moiety of each co-tenant is ascertained by the court with the aid of a master. An interlocutory decree is then entered directing a commission to issue to certain persons to make the partition in the manner prescribed in the decree, and directing the parties to execute the necessary conveyances. After being duly sworn, the commissioners examine the premises, give notice to all parties interested of the time and place of making the partition, and then proceed to set off the shares in the proportion stated in the decree. A full report of all their doings is certified to the court. Unless it appears that the commissioners have acted on wholly erroneous principles or have made a grossly unequal and unjust division, a final decree is entered confirming the report. Under modern procedure, if the commissioners find an actual partition impracticable, they may so report and advise a sale. The decree of partition and the confirmation of the report of the commissioners did not, according to the original equity practice, transfer or convey the title. This could only be done by act of the parties. Formally, therefore, every partition in equity included a decree that the parties make mutual conveyances to effectually carry out the allotments of the commissioners. In some states the court is authorized to appoint a commissioner to execute conveyances in the names of the parties. At the present time, the general rule, either by statute or judicial decision, is that mutual conveyances are not necessary. The partition is regarded as consummated and the titles vested in severalty to the respective shares by virtue of the final decree. Section 722, Partition by means of sale. On account of the difficulty of making an equitable apportionment and division of the land, it might sometimes be expedient for the court to order a sale of the property and a division of his by the original equitable jurisdiction, independent of any statute. If all the parties sui juris were willing, the court had power to decree a sale, and this, even though infants might be among the parties interested. But where one of the parties sui juris refused his consent, the court had no option but to proceed with the ordinary mode of partition. This restriction has in England been removed by a modern statute. In the United States an unqualified power of sale has been conferred on the courts in very many of the states, the power to be exercised whenever it shall appear to the court, independently of the consent of the parties, that a sale would be more beneficial, or less injurious, than an actual partition. As between a sale and a partition, however, the courts will favor a partition, as not disturbing the existing form of the inheritance. A party who desires a sale must assume the burden of showing that a good cause exists therefore, and when the grounds for a sale, which are usually prescribed by statute, are duly established, it, like an actual partition, may be demanded as of right. The court may order an actual partition of a part of the premises and a sale of the remainder. The sale is usually conducted by a referee or commissioner appointed by the court, who makes a certified report of all his doings. The court may vacate or confirm the sale, a confirmation of the sale being essential to its validity. A bidder at a sale, being regarded merely as an offerer, cannot complain if the court refuses confirmation and orders a resale. The grounds on which a resale will be ordered are various and are no different from those on which other judicial sales may be avoided. After confirmation, the proceeds are distributed according to the various rights and interests before the court,